Okay, in the interest of time and that we have a limited amount of time today, about an hour, and a lot to cover, we're going to get started as a few more participants join. I want to thank you all. Again, my name is Eric Hauge. I'm the Executive Director of Homeline. I want to thank you for joining our webinar today. We set this up a little over a week ago, just based on the number of calls that we're getting from clients. And really we're overwhelmed with the response. So we have hundreds of folks on, and we received a good number of questions in advance. So the plan for today is we have about Mike Vra, our managing attorney and director of our hotline, is going to cover some basic topics, kind of the most important key items that have happened regarding tenant landlord law in Minnesota and the COVID-19 pandemic for about 20 minutes or so. And then we're going to try to tackle some of the most common questions that we received already, some of the more, the questions that are kind of more widespread and impact many people, and that will answer a lot of the questions we received in advance. And if there is time after that, we will get to some of the questions submitted online through the Zoom platform. So this is set up like a webinar. So you should only be seeing probably Mike, our managing attorney, in a little window box there. And then we will have a PowerPoint presentation that is screen shared that you should see. Because of the number of attendees, we have close to 500 participants. We have to keep everybody muted. And if you want to submit a question, please do that via the Q&A tool, which is available on the Zoom platform. It'll let you submit a question to us. And as I said, we have a lot that were submitted in advance. We may not get to all of them. So we have made a decision that our plan is to do this weekly. Every Wednesday, probably at the same time, 1:30, we will be hosting follow-up webinars, and hopefully can get to more Q&A during each of those. Today's presentation is designed more for tenants, for an audience of tenants, service providers, social workers, those types of folks. And we have another one scheduled tomorrow at 1:30 that's designed more for landlords and tenants. And that's what we'll continue to do on a weekly basis, Wednesdays at 1:30 and Thursdays at 1:30. All right, so with that, I'm just going to run something through really quick, an introduction to Homeline. We are a statewide organization that provides free legal advice for renters. We've advised approximately 250,000 renters since opening in 1992. Our main program is our tenant hotline, and any renter can contact us via phone or email in 4 different languages: English, Spanish, Somali, or Hmong, to get specific legal advice about their situation. We have a staff of 17, including experienced housing attorneys, advocates, organizers, and we rely on many volunteers and interns, community members, and law students. Today, I'm going to hand it over to Mike Vra, our managing attorney, to go through the presentation. Again, just a quick disclaimer that that this is a generalized webinar, generalized training. We cannot provide specific legal advice over this format. And so we did receive a lot of very specific questions in advance. We can't really answer specific questions unless tenants call us individually on our tenant hotline, and we'll share that information at the end about how you can contact us via phone or email. So with that, I'm going to hand it over to Mike.
Thanks, Eric. Hello, everyone. Thanks for joining us. We put this together essentially to cover the rules as they exist today. I'm actually going to announce today, because we're recording this and we'll probably post it online. It is Wednesday, April 22nd, 2020. That's very important because, well, the rules are fluid. In the last 5 weeks, we've seen the eviction issue, which is probably the most important one for landlord-tenant law. The law on that change in a couple different directions, some by court orders, then by executive orders. And we fully expect that in 2 or 3 weeks that things might be different. There might be some new legislation, there might be a new executive order. Eric, go ahead and put the whole slide up on each slide. Eric is in control of these, and I don't think there's any way for me to do this effectively otherwise. Let's start with the current state of evictions in Minnesota. So to start, the governor has issued an executive order 20-14 that limits evictions substantially. As many of you know, 93% roughly of all evictions in Minnesota are traditionally filed for non-payment of rent. Almost every eviction is for non-payment of rent. That's what they're filed for. Those evictions cannot effectively be filed right now. In theory, they can be filed, but they won't be scheduled. And it's not really clear if a landlord were to file an eviction right now, if that would make them go to the front of the line later or not, or if they just get dismissed and have to file again. We're not entirely sure what would happen because we haven't gotten to that point when the eviction moratorium gets lifted. A landlord still can evict for a couple situations. One is if the tenant seriously endangers neighbors or somebody else by keeping possession, or for a violation of a specific statute that has been around since the early 90s that talks about drugs, guns, prostitution, and stolen property. That's really it. That's what landlords can file evictions for right now, today. Other than that, the court is basically closed for landlords trying to file an eviction. Also in the governor's order, the landlord cannot terminate a residential lease during the pendency of the emergency. This is a little bit tricky because landlords don't very often just say you have to go today. They might say you have to go at the end of next month. And so the question becomes, if a landlord gives a notice to vacate for the end of May, for instance, and we're again in late April, is that violating the spirit or the letter of this statute? As we understand it, the Attorney General's office, who is tasked with enforcing these rules, is not going after landlords that give a notice to vacate for a point in the future. But if a landlord had given a notice for the end of April, in late March, that would have no real legal effect. If the tenant doesn't go, there's not much the landlord can do. And we encourage tenants to contact the Attorney General's office anytime they feel like they're being either evicted or threatened with an eviction right now, as that is their job to enforce this, and the Attorney General's office has been enforcing this. One key provision of the of the governor's executive order is that rent is still due. I know that one of our questions, actually several of our questions, are about rent strikes and the legality of those, and we'll talk about that when we get to the questions, but the short answer is rent is still owed at this point. Okay, Eric, if you could go ahead, thanks. So the next key question, how long does this eviction ban last? We're not sure, is the short answer. Anything else is a best guess. I can tell you some technical stuff. The version of the eviction ban that we have now is tied to the peacetime emergency. They're both orders from the governor. And that peacetime emergency that we have currently runs through May 13th of 2020. Can the governor extend that? Almost certainly yes. The state legislature could also extend it. The state legislature could also stop it, but it would have to be by an agreement with both houses. It can't just be one, the Senate or the House, or the governor could decide to stop with the peacetime emergency and the eviction moratorium whenever he decides to do so. It's much more complicated than that, but that is a decent summary of where we're at right now as far as when the eviction ban will be lifted. Go ahead, Eric. Many of you, I saw the list of people that signed up for this webinar today, have heard me speak in other settings before, almost certainly not on a screen, as I've given a lot of speeches around the state. But one of the things I frequently say in my speeches is that we're talking about state laws almost exclusively, with the exception of discrimination. Almost all of landlord-tenant law is guided by state law, except for some city rules, but not at the federal level. The federal level, it almost never matters what landlord-tenant rules might exist because it's state law specific stuff. That changed in late March of this year when federal legislation was passed called the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act. It bans evictions, charging of late fees and other penalties for non-payment of rent through July 25th of 2020. But then if the landlord wishes to, they would have to give a tenant 30 days notice after July 25th saying, hey, you owe money and we're going to go file an eviction because you haven't paid your rent. But the key part of the CARES Act, go ahead to the next slide, Eric, is what does it cover? Or who does it cover? So it certainly covers a really big umbrella of federally subsidized places. Virtually anything that's covered by the Violence Against Women Act, VAWA, is covered. So we have a list of things that would be covered. Almost anything else you can think of where there's federal subsidies happening is covered by the CARES Act. That's actually fairly easy to find and to look up. The harder stuff is the CARES Act also includes properties with federally backed mortgage loans. So what are those? Fannie Mae, Freddie Mac. It's a whole host of other programs that might have federally backed mortgages. And honestly, it's something that a tenant would have a very difficult time finding out. An attorney would have a very difficult time finding out. Probably it's got to be the landlord trying to figure out where their mortgage actually came from. Now, a lot of landlords, and this includes somebody with one unit or a duplex or something like that. How would a landlord know? Many landlords won't even know if they have a federally backed mortgage. They got their mortgage at the bank down the street or in the town, one city over. They don't know where their mortgage actually came from. They're probably going to need to go back and do some sleuthing with their mortgage provider to try to figure out whether they have any federally backing in their mortgage. And if they do, then that landlord is bound by the CARES Act. We've put together some numbers. Our best guess, 30, maybe 50% of Minnesota rentals are covered by the CARES Act. So this federal legislation has a huge impact on the eviction world, which is, like I said, normally a state law domain. Obviously, we haven't seen this defended yet in court because there aren't really evictions being filed in Minnesota. So we're not sure what courts are going to do with this. There is some concern that the CARES Act doesn't have a lot of what we lawyers call teeth. There's not really a penalty built into it like the Minnesota moratorium on evictions, where we saw the misdemeanor that the Attorney General could go after a landlord for with $1,000, up to $1,000 and up to 90 days in jail for violating the state law. That doesn't exist in the CARES Act. But we have seen some guidance from an out-of-state court. Michigan's Supreme Court issued several pieces of an administrative order last week where they essentially said that a landlord would have to affirm that they're not covered by the CARES Act in order to file an eviction. We can't be sure that Minnesota will follow the same route that Michigan's state Supreme Court did, but it's so far the most official piece of guidance I've seen on what a court is likely to require. We've heard rumblings that the 4th Judicial District, which is where Minneapolis is, will be going in the same direction, that they're going to ask for some sort of affirmation by the landlord that they aren't covered by the CARES Act. Okay, Eric, go on.
Just one quick addition. This is Eric. A large category that's not on the slide, it's in the many others, is low-income housing tax credit properties, or Section 42. It's a very large number of those units throughout our state.
All right. Minnesota courts have issued some rules of their own that have been, again, sort of all over the map in the last 5 weeks. But what we can tell you right now currently, for the stuff that we are most concerned about, landlord-tenant housing issues, evictions won't be scheduled unless for what we talked about earlier, endangering others, drugs, guns, etc. An ETRA, an emergency tenant remedies action, can be heard now. So a tenant doesn't have running water. We were talking to a tenant on our hotline a couple days ago that is dealing with that, and they threatened the ETRA, and they could have actually filed it. A lockout or ouster, where the landlord has turned off the power or changed the locks or turned off the water to try to force a tenant out who isn't paying. Those can be heard by courts now. A rent escrow, which is the most common tool that tenants use to try to force landlords to make repairs, is not being scheduled currently, nor are conciliation court cases, which, again, in our line of work is traditionally security deposit cases, where a tenant's trying to recover their security deposit. Those really can't be I guess technically you can file them, but we're not sure what happens once the courts open back up again, if they're all just going to get flushed and people will have to refile, or if they'll jump in the front of the line. We don't know. But right now they aren't being heard or scheduled. Okay, Eric, thank you. Another couple things that we should bring up, the price gouging issue. Again, we're talking about things that we are hearing lots of questions on our tenant hotline. We've taken about, last I checked this morning, 725 calls that are COVID-19 related calls about landlord-tenant law. And one of the things that we're hearing about some of the time is rent increases. We are honestly in rent increase season. This is when landlords let tenants know, hey, your lease is coming up sometime this summer, so we're going to be raising your rent. My sense is that a lot of landlords are just sort of going with their schedule. They've decided earlier this year, or maybe a 5-year plan of how they were going to keep increasing their rent if they thought the market would bear it. And so some landlords are staying the course and issuing rent increases. Some landlords are not, by the way. We've actually seen a couple landlords lowering their rent, realizing, hey, we need to keep the people in our units that are actually paying their rent, because we have, some percent. We've seen somewhere between 10 and 30% of Minnesota renters, maybe our best guess, is not paying rent or hasn't paid rent for April yet. So anyhow, landlords might be incentivized to try to keep the current tenants they have. But the governor's price gouging order has a couple of limits. A rent increase, and this certainly applies to housing, the price gouging rule, can't be more than a 20% increase, or a disparity between the price of the good a month before the peacetime emergency was declared. The penalty is quite a bit more severe here. The $10,000 penalty per sale or transaction that the Attorney General can go after the landlord for. There's no misdemeanor built into it, but still, that dollar number is quite a bit higher than the 1,000 from the other order that we talked about. Go ahead, Eric. So another question we've gotten a lot of: can tenants move? We have our shelter-in-place order, which the first version of it, by the way, there's been 2 versions of the shelter-in-place order. The first version of it did not indicate that tenants were allowed to move into a new rental situation, or a homeowner even moving into a new purchase. But the new version of the order has clarified that, saying that people are allowed to move into a new home or place of residence. So again, this is the season when people move in and move out. And this is permitted for people to move in and move out. Go ahead, Eric. Okay, so one of maybe the most contentious issue that we've been dealing with over the last 5 weeks is something that we've dealt with in the past many times: the question of when the landlord can enter the rental unit. But in recent years, that question has been, we keep track of why people call our tenant hotline, and we have about 75 categories, and it's always in the top 10. When can the landlord come in? But now it's number 2 or 3. 200 or 300% increase in privacy questions, for obvious reasons. Nobody wants any stranger, or anybody else, frankly, even people that they know and maybe are related to enter their homes right now. But we have a rule that says that a landlord can enter a property, a rental property, if they have a reasonable business purpose and they attempt to give reasonable notice. Now, showings, which is the most common thing we're hearing about, if the tenant asks the landlord to come in and make repairs, and the landlord is okay with that, both sides are agreeing, that's fine. But showings, where the tenant is given a notice to vacate, they're leaving at the end of April or the end of May or the end of June, and the landlord wants to show the unit to a prospective tenant, showings are actually explicitly listed in the statute as being an allowable business purpose for landlords to enter. However, the entire statute has this, we put this in quotes, "under the circumstances" phrase within the statute, which I've been doing this work since 1996, and this law has existed since then. And I don't think I'd ever looked at that 3-word grouping before the last 5 weeks. It wasn't really that important. But right now, the circumstances are so different and so dangerous to have somebody entering your home potentially, that we are giving modified advice on this issue. And we've prepared a statement position on privacy that we'll be putting up on our website any day now. It's taken a lot of thought and effort to try to figure out what exactly we think tenants can or can't do. But the gist is that if somebody has a higher level of concern health-wise about the COVID-19 situation, they are elderly, their immunity system's compromised, or somebody in the family is. Something like that, maybe under the circumstances, a tenant doesn't have to let a landlord in. It's not especially clear what a landlord could do to a tenant if the tenant refuses access. And I mean that, refusing access, not opening the door, or keeping the deadbolt closed, or the chain on the door, or moving a dresser in front of the door. Would that be illegal? Well, the landlord could call the police. The police are going to come out and almost certainly will say, this is a civil matter, take it to court, landlord. The landlord's normal remedy against a tenant doing something like this would be to go file an eviction. But again, the landlord can't file the eviction unless there's an endangering of safety, or the drugs, guns, prostitution thing. Probably not there. And so it's a tricky question. It's case by case. And one of the things that we are encouraging people to do is have your clients, I know that most of the people that signed up for today's webinar are people that work in the social work field or government agencies, is to have your clients call us directly. This is what we do. We have, our staff is fully functional, as much as it always has been. We take emails and phone calls for free. They're confidential. And we'll try to get tenants the right answer based on their exact situation. Okay, go ahead to the next screen. There's the summary of how to reach us. And that was a little bit over the 20 minutes I think we promised for our prepared materials. But at this point, I'm ready to take the questions that we've had submitted over the week. Eric, if you want to launch into the first one.
Yeah, a quick clarifying question to go back to the stay-at-home order.
Yep.
And the eviction order. Is it right that a tenant can move out at this time, but probably it has to be at the end of their lease?
Well, a tenant can go anytime they want. I mean, nobody's locked into their home physically. If it's at the end of their lease and they've given a notice, they certainly can move out. There's no question that a tenant can do that, just like they always have been able to do. But leaving the lease early, there's no special law that says that a tenant gets to leave their lease early. Some landlords are allowing tenants to go early because they figure, what's the point in chasing a tenant who maybe can't afford to pay or something like that. So, but there's no specific, I get out of my lease because of COVID-19 rule that's been issued by anybody yet.
And a number of comments quickly. People are asking about if we can get a copy of the PowerPoint. Yes. At the end of this, you'll be sent to our website, and we have a specific COVID page. The PowerPoint's not up there yet, but a number of other resources are, and we'll be adding to that list of resources with some of the stuff that was talked about today. So again, we're going to answer the questions that we got that were submitted during registration. We got many questions. And we'll get to those first, and if we have time, we'll get to others. Otherwise, you can join us again next week, or if you're a tenant, call us directly on our hotline. In Minnesota, during this health crisis, can landlords apply late fees?
Late fees are allowed in Minnesota unless you're covered by the CARES Act, is the short answer. I know that there is proposed legislation in both the Minnesota Senate and House that would eliminate the landlord's ability to collect late fees. An organization called the Minnesota Multi-Housing Association, which is a landlord representative group, issued a series of recommendations, and they recommended that no late fees be collected during the COVID-19 crisis. But that's not a law. It's just a recommendation from kind of that trade group. But yes, a landlord that's not covered by the CARES Act, in theory, can still collect late fees. We are seeing some landlords insist on late fees being paid. Many landlords are waiving late fees if the tenant is willing to sign some sort of payment agreement, which I know there's further questions about that, so I'll leave it at that.
And if somebody's in a CARES Act building and they're charged late fees, what should they do? Just refuse?
The tenant could say, hey, look, I think I'm covered by the CARES Act. I don't think you can charge me a late fee. I'll be honest, there's going to be a lot of landlords that won't have any idea whether they're covered by it or not, or even if they are covered and they know it, they don't realize that there's a late fees prohibition. So it's hard to know exactly how a landlord would deal with that.
Next
but
question.
You want to point it out. Yeah.
Next question. What are the details of who tenants can contact for rental assistance? Are there specific resources for folks who might be residents who might be undocumented too?
Eric, I'll let you talk about what's on our website about that. That's probably a better question for you.
Yeah, so we do have a section on our website that's, if you go to homelinemn.org, it's right in, you'll notice it right away, that you can click to the COVID section, and that has some information about some of the key items that Mike's talked about during the beginning of the presentation, and some links to some of the specific funds that have been opened. For example, the Minneapolis Gap Fund that just opened this morning, and a number of these funds on a local level are accessible to people who might be undocumented. We've also heard there's a number of private foundations that are working to set up additional funds that would that people would be able to access, and we'll try to continue to keep our webpage updated with links to those resources.
And I assume anybody calling 211 would probably access the most recent information as well, right?
I would think so, yeah.
Sure.
Next question: if a client put in a notice to vacate for April 30, can the client stay in their current unit while avoiding an eviction?
Okay, good question, and something that we're dealing with. So a tenant might have given a notice thinking they were going to be able to find a new place to move into, or maybe they had some other place lined up, but the person that's living there is refusing to go, so they can't move into their new expected place. Short answer, once again, the landlord's real remedy, if a tenant holds over, which is what we call that, that's the legal term for it. If the tenant holds over, they're supposed to leave April 30th, but they're there on May 1st, the landlord's remedy is to go file an eviction, which is a UD or an unlawful detainer. They're all the same thing. But right now, the landlord can't really file the eviction for that purpose. And so the tenant wouldn't be evicted. That's, I guess, the good news for the current tenant that wants to stay. The bad news is, in theory, the landlord could, I guess, sue that tenant for consequential damages. So if the new person was supposed to move in on May 1st but couldn't, then they had the rental truck for a couple extra nights. They had to go stay in a hotel for a few nights until they found a new place to move into. These are all expenses that prospective tenant that was supposed to move in May 1st might be incurring. So the landlord might get sued eventually by that tenant that was supposed to move in May 1st and try to pass those costs on to the current tenant. So although an eviction can't really be filed to physically remove somebody, there might be still some financial consequences for the current tenant that decides to hold over.
Can a landlord require the full payment of an attorney fee in order to secure residency, even after rent and eviction fee have been paid?
So there's actually a specific law in Minnesota about attorney's fees when it comes to non-payment of rent evictions, which again is more than 9 out of 10 evictions are for non-payment of rent. It caps attorney's fees if the tenant is just trying to stay in their home during their lease at $5, which is, you didn't mishear that, it's a $5 cap on attorney's fees. That rule's been there forever, obviously. And the theory is that landlords should be able to file a non-payment of rent eviction without hiring an attorney. That seems to have always been the theory. And so would a landlord have a claim against a tenant for those attorney's fees? Well, first of all, the lease would have to say so. The lease would have to say that attorney's fees are necessary. But then the landlord could only really chase the tenant for that money either in small claims court, I suppose during the tenancy, but most would wait until the end of the tenancy, keep it out of the deposit, or if it doesn't, the deposit doesn't cover those attorney's fees, to try to chase the tenant for more money later. But the landlord can't condition staying in the place if they file the non-payment of rent eviction on the tenant paying attorney's fees, and that's by statute.
Can landlords do non-renewals of leases? For example, notice to vacate due to asking to non-renew the lease during the peacetime emergency.
Yeah, and we talked about this a little bit earlier, but I'll cover it again because it's something that matters a lot to people, especially during the warm weather months that we're starting to get to when people move in and move out. A landlord can't give a notice to vacate during the peacetime emergency. So effective for the tenant to leave by the end of April, it would be an ineffective notice to vacate. If the tenant refuses to go, there's not much the landlord can do to chase them out. The harder question is if a landlord gave a notice for the end of May or the end of June, which right now is not covered by the peacetime emergency, would that notice still hold up later on? And we don't know the answer to that question.
Do you have some tips for renters as far as negotiating payment plans with landlords?
Yeah, the first tip is the first main ask that I think a tenant should do is I want to get late fees waived. I assume anybody that's not paying their rent right now is not paying their rent because of COVID-19, at least on some level. They lost their job, their whatever other income source they might have is depleted, and there's no savings left. So the first thing that I would recommend asking the landlord for is I want to get the late fees waived. I've heard that lots of landlords are doing that, which is very true. Many landlords are doing it. In fact, on April 1st, we got inundated from tenants all around the state, landlords sending out, if you can't pay letters, here's what we're willing to try to do to work with you. And most of those letters sent by really large landlords generally were saying that if you agree to some sort of payment plan, tell us what you can pay and when you can pay it, basically, then we will waive the late fees if you live up to that payment plan, if the landlord approved the payment plan. So asking for the late fees to be waived is the first thing I would do, even though it might be covered by the CARES Act and it might be covered by legislation that may be created, we don't know. Right now, the governor's order does not stop late fees, so I would insist on that as part of a payment plan. The other thing that I always talk about with payment plans is getting the payment plan in writing, so everybody knows what that's being agreed to. Tenants should be really cautious with these payment plans and not promise things that they can't live up to. As we talked about earlier, we don't know when the eviction moratorium will be lifted, but we are confident that eventually it will be lifted. And once it is, then landlords, whether they have to give some sort of notice or not, are eventually going to expect to get paid. And so payment plans, I have to assume, are going to help tenants convince landlords, once the eviction moratorium gets lifted, that they should stay with that tenant, versus a tenant that says, I'm not going to pay, or never really communicates with the landlord at all, and doesn't pay. I think that the landlord that gets contacted by the tenants that say, hey, I'm doing what I can, and I know the rent's $1,000, but I can give you $400 this month and $400 next month, and once I get back on my feet and get a job again, we'll start paying. But so I like the idea of payment plans. Again, they should be in writing. They should ask for late fees to be waived. And tenants should think carefully before they sign on to something, agreeing to it, having some confidence that they're going to have the money that they're promising.
We have a clarifying question on something that you covered just briefly a couple minutes ago about the notice to vacate for April 30th. If a client was supposed to leave on April 30th but refused to, are they at threat of an eviction later down the line?
Maybe not. It depends on what happens. If the tenant were there on April 30th and they were supposed to leave by April 30th and they stayed into May 1st, if the tenant paid rent and the landlord accepted rent for May, that notice to vacate might be waived effectively. The court could and probably should rule that way. If there is no rent paid in May, that's different. Then I think the landlord would have a holding over case that's pretty solid when the eviction moratorium eventually gets lifted.
Next question, what time frame does the governor's order protect clients from eviction? Is there an end date?
Yeah, the end date is really hard to know right now, which is honestly one of the reasons why we're planning to do this once a week. We'll have a better sense every week, and this is what we do is landlord-tenant law, and I know that the people that signed up for this, very few of you do nothing but landlord-tenant law. You do a lot of other things and wear a lot of other hats, and maybe you're a renter yourself. But this is what we do, and so it's our job to stay informed on what's going on, and that's why we're sharing the information as freely as we can. But right now, May 13th is the official date for Minnesota's governor, and as mentioned earlier, I think it was July 25th is when the CARES Act officially expires. So those are the dates that we have in mind today, but we don't know what will happen as May 13th gets closer.
What the governor did in April was to extend it 30 days, but and that in theory could happen again, but we have to tell folks what the actual date is. The next question, evictions after moratorium is over, what happens next? If a tenant is protected from eviction by the moratorium, could they be immediately evicted when it's lifted? So that kind of got answered a little bit, but.
Yeah, let me talk a little bit about kind of trying to predict the eviction world after the moratorium is lifted. Look, at some point, there's not going to be any more moratoriums, right? The CARES Act is gone. The governor's moratorium is lifted. At some point, all of this protection for tenants, they can't be evicted, that's going to be gone. And we don't know exactly what's going to happen next because we've never been through this. My hunch is that there will be thousands, if not tens of thousands, of evictions filed in very short order after the moratoriums are lifted. The courts aren't built for that. Right now, or I should say not right now, but in the last 10 years, the average number of evictions in Minnesota went between, 15 to 20,000, somewhere in there is the range of evictions per year in the entire state. And as I just mentioned, we're going to see 1,000 to tens of thousands, maybe more, of evictions filed in a span of 4 or 5 days. What are the courts going to do with that? There's some legislation that I'm not sure where exactly it is in the legislature. I don't know if you know, Eric, that the courts have more time leniency on getting things heard. Evictions are, by law, at the current under the current rules, supposed to occur, the actual first initial hearing, within 7 to 14 days of the landlord filing the case. It's a summary proceeding. It's a very limited jurisdiction for the court. They can only do so much. They basically decide who gets possession, but these cases happen fast. That's what landlords get, is a fast case. But the legislation that's been proposed, and I'm again not sure the status of it, I don't think it was controversial, was to delay mandatory time required court compliance, things like the eviction 7 to 14 day rule. So even if there is an eviction moratorium lift, it might take the courts much longer to process all of these cases. On average, under the old rules, it was 20 to 30 days on average to get a tenant out when a landlord filed an eviction. That might be pushed back quite a bit depending on when the court can actually hear the case. There's also going to be questions about whether the court hears cases in person. Will tenants be able to show up and make an argument, or do they have to appear electronically, which for many of our clients might be exceptionally difficult to do? Will they be allowed to speak over the phone? And so we have a lot of concerns about the efficiency of courts versus making sure that they're not too efficient and just run over everyone's rights.
Yeah, 2 points on that. I believe that the legislation that gave the courts the flexibility to extend deadlines, such as the eviction deadline, did pass last week. Again, it gives the courts the flexibility. It doesn't obligate them to.
Right.
So on a court by court basis, they could deal with it differently. The other thing I'd add is, before Walz did his executive order 2014 that suspended evictions, the courts were trying to figure out themselves what to do, and they were issuing a number of orders, one of which was going to allow flexibility for, as you said, the remote hearings and things like that, which could be very harmful for our clients. The next question: what advice can you give to groups taking part in a rent strike?
Yeah, and we've gotten this question a lot, not just from groups, sometimes from individuals. There's been a lot of press nationally and at the local level, and certainly a ton of social media movement towards the concept of a rent strike. These are called different things by different people, but the general concept is tenants withhold their rent or simply don't pay it because they don't have it. And instead of saying as a tenant, I'll get caught up when I can get caught up, their request or their argument is that there should be no rent owed, that the landlord should have to waive the rent requirement, or that maybe somebody else should pay it, the government or some other entity. But the most traditional version of this is that the tenants are simply demanding that a landlord not be able to collect rent. There isn't really any legal footing for this. We have been advising people, asking us, how do I assert a rent strike? Well, there's not really a mechanism in place because it's not legally sanctioned by a court. And so let's say a tenant or a group of tenants decides to go on a rent strike withholding their rent, and then the eviction moratorium is eventually lifted. And then the landlord goes and files an eviction saying you didn't pay your rent. And then the tenants say, hey, I told my landlord a rent strike. I gave them a form that said I'm on a rent strike. I don't think the judge will really think that matters under the current rules. Judges' jobs aren't to, in general, say or invalidate a law. It's to enforce the laws that they have in front of them. If a group of tenants really wants a rent strike to work, their best and maybe only realistic hope for making those work is to convince legislators that the law has to change on this. And so that's what we're encouraging every tenant or group of tenants to do, is to contact their legislators who, there's some movement at some legislative levels to get rent waived. And if that happens, then courts can enforce it. But simply declaring a rent strike under the current rules that we have, again, not really grounded on any legal footing.
Next question. How can case managers better assist tenants when they're being served eviction notices from their landlords? Who can renters call during this time if they have problems with the landlord or management company?
Yeah, and this is something we brought up earlier, and we'll say it again. We want to hear from tenants directly about this. So social workers will frequently contact us on behalf of tenants. We can't talk to social workers directly. We can talk to the tenants. And so one of the most effective ways to make that happen is the social worker will help the tenant compose an email. Again, that's a free service. It's confidential. Help compose an email to our email and attorney service and explain the question, and then we'll send the email back to the tenant. Now, the tenant at that point is welcome to share the answer with the social worker, but we have, as attorneys, a duty of confidentiality to the client themselves. And so we need their authorization to be able to share it with a social worker or some government official or something like that. Like I said, if it's an email, then they're free to share it with whoever they like once we send it back to them. But we want them to contact us. There's a lot of case-by-case issues that come up. There just are. And so we try to give the blanket information as much as we possibly can. That's why we're giving a webinar like this and including the information that we have on our webpage, because it answers a lot of the questions. But the nuances, the details really matter a lot in helping people understand, first of all, what their options are and maybe the likely consequences of those options.
And the next question. My lease ends on April 30th. Management keeps sending me emails about moving out. What should I do? I don't have anywhere to go because I've not found a place.
Yep, and we have talked about this, but again, the tenant, I think, is best served to tell the landlord today. I mean, that's 9 days away, whatever it is. Tell the landlord today, I'm not going to be able to move when you thought I was going to be able to move. And so I hope you're able to tell the next tenant that was supposed to move in, if that's the case, that this will not be available. And, you know, I'm sorry, but I don't have anywhere to go. The longer lead time the landlord has on that, the less likely they are to try to sue the current tenant for some of those consequential damages that we talked about earlier.
How can tenants get the same results as filing a rent escrow case while the courthouse is not open to the public?
Yeah, this is hard right now. Repairs are almost always, not today, but almost always our number one reason for calls. Landlords aren't fixing things. Tenants call us up saying, hey, my landlord isn't fixing something. What do I do? And the rent escrow is the primary tool that a tenant has to force a landlord to make repairs. So to start with, rent escrows need one of two things to begin. One is city inspector has come out and given the landlord a deadline to fix something that needs to be fixed. That's one way to start a rent escrow. The other way is for a tenant to simply give what we call a 14-day letter. We have these available on our website. We're a free service, and that's a free service for tenants to download the repair request form, which is our most commonly downloaded form. So a tenant can actually start the rent escrow process by giving the 14-day letter now. You don't have to wait for the courts to be open to give the 14-day letter. So the tenant giving the 14-day letter would be the first move in a rent escrow. Many times, having done this for a long time, many times that letter, citing the statute, looking really official, convinces the landlord to solve the problem, to fix the problem, because they don't want to deal with the rent escrow later on. And so I'm hoping that landlords will get that 14-day letter and solve the problem. If they don't, as soon as the courts open up, the tenant can go to court with that 14-day letter because the 14 days have passed and say, I'm ready to file my case right now. Like all situations like this, documenting the conditions. So maybe an extra email or two showing photos or a video if you've got a leak coming through the ceiling that doesn't show up very well in a photo, but a video showing the water coming. And proof that you've been telling the landlord about it all this time would help later on with a rent escrow kind of case. But again, it's kind of case by case that we go through this.
And on that front, clarifying question, what about city inspectors?
Yeah, we're hearing mixed results about what city inspectors are doing right now. I think if you called up and you said, you know, I've got a life-threatening issue going on here, the city inspectors are likely to come out, although I can't make you that guarantee. And first of all, not every city has an inspector. The further you get away from the metro, the less likely you are to have inspectors. And then, you know, when you get back to the larger cities throughout the state, again, you might have an inspector, but not every city has them. But if they do have them, I think it's really important to not just say, hey, I want an inspection, but to specify exactly what the issue is. And again, if there's some sort of life-threatening aspect to the issue or makes it unlivable almost in an emergency sense, then the inspectors might be able to prioritize that.
So it's going to be on a very city by city basis. And
it always is.
One thing I've heard is some inspectors are receiving stuff remotely too. If you can get photos or.
Oh, sure. Yeah, if an inspector can look it over remotely. I'm not sure how effective or official their reports would be, which we really care about, but inspectors have other ways to get landlords to do things. They'll call up a landlord and say, hey, look, I saw the email, here it is, so you can see what I'm looking at. You got to get over there and solve that now, or else I'm going to have to come out and write up a report. You don't want me to do that. They have the ability to try to convince landlords to do stuff.
What about landlords who refuse partial payments? Is there a relaxation of this policy during the shutdown?
Yeah, I think that there's absolutely, well, first of all, built into that question is somebody's pretty knowledgeable about landlords and sort of what they do when it comes to partial payment offers. Many landlords will say in Minnesota, I'm never going to accept a partial payment. The reason why is we think it hurts our chances to win an eviction later. Now, there are reasons why that's a good policy for landlords. There's reasons why that's maybe not a great policy for landlords. But that policy from landlords, we're seeing relaxed substantially right now because landlords are looking to get any rent, basically. And so to say we're not going to accept partial payments would be just cutting off an income source that landlords desperately are in need of right now. So we're seeing a lot more landlords relaxing their partial payment rules. From a landlord perspective, the partial payment, big concern about it is somehow that you're waiving a right to evict for failure to pay rent. But that's actually not right. The statute that talks about partial payments, what it really wants a landlord to do is to write down what the agreement is. And so I think landlords are still pretty well protected. They could go file an eviction for non-payment of rent eventually if they're accepting partial payments, if they put that into their partial payment agreement. Hey, if you don't make all the payments, then as soon as the moratorium is lifted, I have the right to go file an eviction against you for non-payment of rent.
Can a mutual termination agreement be enforced if signed under coercion?
Yeah, so a mutual termination agreement is where the landlord, based on how the question is framed, it's where the landlord is probably saying, hey, tenant, I want you gone. If you don't go, I'm going to go file an eviction against you or something like that. We get this question a lot, coercion. You know, I was coerced into signing a new lease, or I was coerced into renewing a lease, or I was coerced into signing an agreement to vacate. Coercion's a tough standard to get to legally. I mean, sort of the prototype law school version of coercion is somebody's holding a gun to your head saying, sign this or else I pull the trigger, or, you know, to your kid's head or whatever. But actually a threat of violence if you don't do something. That's on one end of the spectrum of coercion. And on the other end is, hey, if you don't pay your rent this month, I'm going to go file an eviction against you for non-payment of rent. Well, I guess that's coercive too. So coercion's always sort of thought about on this level of a spectrum. But a mutual termination, again, if the tenant signs one right now saying they'll leave by the end of April, and then they don't leave at the end of April, there's not much more the landlord can do. May 1, they can't file that eviction. So if I'm a careful landlord and my primary goal is to get that tenant out as soon as I possibly can, I won't accept rent for May. But once I do accept rent for May, that makes my case a lot harder. That mutual termination might not mean anything at all at that point.
Can tenants be given notices to vacate that are not legal evictions at this time?
Yeah, we've talked about that a little bit already, but it's where the landlord is trying to give a notice to vacate for the post-eviction moratorium space, whether that will be allowed or not. You could make an argument that simply giving a notice to vacate right now, even effective for the end of May or June, is violating the governor's executive order. From what we understand, the Attorney General's office is not going after people that do that because we are seeing landlords do that. And again, everything gets thrown into whack if the governor extends the eviction moratorium once again into, let's say, June, a month later. What would happen to those notices to vacate? They'd probably, if the landlord tried to enforce them, the Attorney General's office certainly could enforce against that landlord then.
We've had a couple comments come in, very helpful. Minneapolis inspection staff commenting that Minneapolis will be responding to all inspection complaints through 311, and they'll do physical inspections if the situation is deemed urgent and if they cannot verify it virtually. I think St. Paul is doing something very similar. And then if you're outside those cities, you'll have to check with, one-on-one with your city.
Yeah, and I know a lot of city inspectors around the state, and the one thing I know about them is they talk to each other. They share a lot of information and issues and theories about what works and what doesn't work. So I'm sure that there's sort of a collective thought process going on with city inspectors.
Okay, so a couple of questions to try to get to in the last less than 10 minutes here that have come in. Kind of some clarity around the issue of privacy. What if maybe you've asked for a repair and there's repair people coming, but they're not wearing PPE, personal protective equipment?
Well, to start, I'm telling tenants, not just for repair people, but for showings, to do what they can to help minimize the concerns about COVID-19, which basically means you don't want anybody to touch anything, you don't want anybody to breathe on anything. So I think it's perfectly fair game for a tenant to say to a landlord, okay, look, you want a repair guy to come in? I need them to wear a mask, and I need them to be wearing gloves. And I'm going to turn all the lights on, so they don't have to turn any lights on. And if they're going to be fixing the pipe underneath the sink, I'm going to open up the cupboard door so they don't have to touch it, right? Tenants can do whatever they can to help minimize the contact that we're all trying to avoid right now. But yeah, just specifying for the landlord what they expect them to do why not? Is it in the law somewhere that the landlord must do that? I'm not sure that it gets to that level yet. Maybe as the governor's starting to institute more rules about mask necessity in different places. The question is whether that's a public place or not, sort of like a grocery store. I'm not sure where that would go, but I certainly don't see any downside for a tenant asking for it. And look, if the repair person shows up without a mask, the tenant could say, look, come back when you have a mask on. I'm going to email your boss or text your boss telling them this is what I need before you come in. Landlord might say the tenant's doing this unreasonably, but if it ever gets to a court somewhere, that's a pretty sympathetic story, especially if the tenant is immunocompromised.
Does the governor's order impact adult foster care and sober houses?
Probably yes. It's a very difficult question actually to figure out who is a tenant and who's not a tenant legally. Many times, for instance, most of the sober houses in the state, a giant percentage of them, are not anything that anyone would recognize as some sort of official facility. A lot of times it's somebody's house where they have declared it a sober house by virtue of two words at the top of their lease says sober house, which are almost exclusively governed by landlord-tenant law. Some facilities, difficult to know why it wouldn't be covered. You'd have to show me something that says that they're not bound to that eviction moratorium, although it's a little bit beyond what we actually focus on. We just do landlord-tenant law, so some of this transitional housing stuff isn't our area of expertise.
Does the CARES Act cover landlords that have accepted federal tenant-based rental assistance? For example, Section 8, HOPWA, Section 8 vouchers.
Yep, short answer is yes. The voucher seems to certainly be covered under the CARES Act. And that's going to be a large number of Minnesota landlords, for sure. And so there's a real chance that a court is going to say, once the eviction moratorium is lifted, hey, landlord, prove to me that you're not covered by the CARES Act. what's your demonstration of proof? And if the tenant indicates that there's any kind of federal subsidy, that might just stop the whole thing. We're not sure what would happen. It might get dismissed. I could see the court doing that. It's probably, if I had to bet, the most likely result is the court would dismiss the case. Again, the Attorney General's office is not tasked with enforcing the CARES Act, so that might be the one place that matters, is what the court decides as far as what can or can't be heard. But it might be a dismissal similar to if the landlord had not served the court papers correctly to start the case. It might be a threshold issue. That's what we lawyers call it, that you have to get past or else you can't get to the rest of the case.
Can a landlord demand a tenant use their stimulus check to pay rent?
Well, I suppose a landlord could make that request, and they can even call it a demand if they want, but there's not any real legal footing that a landlord has to say, hey, you must pay me with your $1,200 stimulus check. First of all, not everybody gets those. Secondly, people have different bills that they're paying, and the rent might not be the first priority right now if they have no food in the house. And so it's a difficult spot for everybody to be in. But no, there's no law that says the landlord gets to, intervene and grab the money before it gets to the tenant.
Are tenants that are self-employed, such as Uber drivers, and their income has decreased, are they eligible for rent adjustments in subsidized programs?
Probably yes. We're telling anybody in a subsidized program that if their income changes, they should be telling the landlord about it immediately. First of all, they're supposed to. But secondly, it's in their best interest right now because it means their rent should go down. With most subsidies, tenants pay a percentage of their income. So letting the landlord know about the actual income is critical as soon as possible.
And we have some fact sheets on federal subsidy programs and how they're supposed to be responding. So in the case of a Section 8 voucher, you'd have to go to the HRA to ask for that rent readjustment. We'll put that up on our COVID page, more details about that. There's a couple, I think, maybe last minute questions here and a couple comments. Is it possible for folks that have been listening in to set up a time to do a three-way call with a tenant and as a service provider, the service provider, a client, and somebody with Homeline?
Yeah, we do that a lot. You either call and leave a message on our hotline and say, hey, this is who's calling, this is what we're trying to do, when can we set this up? Let's set up a time. Or sending an email, which is probably a more effective way to do this, to our free Email the Attorney service and say, here's what we want to do, here's the issue. Maybe you can send along the lease or texts or emails or things that might matter to address the question that's being asked. But yes, we do set up conversations between tenants if they approve of it, because they, again, have to decide that it's okay, and a social worker.
Do we know if GRH is the program GRH, Group Residential Housing, is considered part of being covered under the CARES Act?
I don't know the answer to that one off the top of my head. Sorry. I would think it is, but and if there's any federal, are there federal underpinnings to that, or is it a state only?
I think it's a state only. So
if it's state only, then it might not apply. Again, we're talking about federal subsidies. That's all that really matters for the CARES Act stepping in. So unless GRH has some underlying funding from the federal government, then it might not count under the CARES program. I don't believe it would.
Yeah, it's I'm getting clarification from several folks. GRH housing support is only state funded.
There you go. If we would have been all in the same room, we would have known the answer immediately.
And we had originally planned to do that, but with close to 400 or over 400 participants, it's been we wanted to try to streamline this. So a couple other things. This is maybe just an offer, but a question too. The comment was, could mediation programs throughout the metro and the state help to solve eviction, threats of eviction, and stay outside of court, as well as maybe come up with a payment plan?
Absolutely, mediation could play that role. Historically, the hurdle for mediation, again, non-payment of rent evictions are almost all the evictions. So then what incentive does the landlord have to participate in mediation is usually the big hurdle to get past. But if it seems like working with a mediator will be more likely to get landlords some money in their pocket, maybe mediation makes a lot of sense right now for landlords, which is great. I mean, if landlords want to go through mediation, that's wonderful. But you need both sides to agree to mediation to make it happen.
And then I did get another comment, a resource in Minneapolis, the Tenant Resource Center, which is a new program on the north side, is still in operation. And I think they're helping to actually get out some of the housing support money. So
Oh,
we'll add a link to our website about the Tenant Resource Center for Minneapolis. And we'll try to update that page on our website, homelinemn.org/COVID. It's accessible from the front page. After this, with some of the materials we've talked about. I think we will probably try to put a recording of this up there. But then a reminder, we will be doing a training, similar training tomorrow for landlords. We're not really policing who goes on what training. It's just a matter of what the how the presentation is designed and what we can share. And then because we have had so much interest in this, we will plan to schedule 2 new trainings next week for the same days and times, Wednesday and Thursday at 1:30, Wednesday for tenants and service providers, Thursday for landlords. We've hit 2:30 and I think we've covered most of the questions, but we will take a look at all the questions that were submitted and to the extent possible, get them answered next week. Any other closing thoughts, Mike?
Nope. Thank you all for joining us. And if you wish to join us again next week, you're welcome to do so. Thanks.
Very much appreciated. Thanks for being a part of this, everyone. Stay safe and healthy.